And to begin, I would like to introduce our esteemed presenters whose full and quite extensive bios can be found on the Animal Law Symposium website. We have Kathleen Foley, staff attorney with the Animal Legal Defense Fund; Thomas Bondy, senior counsel, Supreme Court, Appellate Litigation, Orrick; Camille Labchuk, executive director, Animal Justice. And now for our first presenter, Kathleen Foley.
Thank you, Kathy. Hello, everyone. My name is Kathleen Foley, and I'm a staff attorney at ALDF. I'm going to kick us off with a discussion of Ag-Gag laws by going through a general history of their passage and the threat of investigations into animal facilities that they are intended to target. So to understand Ag-Gag laws, you can first look to investigations. Ag-Gag laws are enacted to target the speech of individuals who perform undercover investigations into the conditions of, among other industries, facilities that raise animals for food. Many of these investigations are employment-based. Namely, an investigator will go undercover to gain employment at a chicken or a pig or a dairy farm without revealing their affiliation or ties to an animal protection organization or a goal. The investigator will perform the normal requirements of the job, and in doing so, observe and potentially capture through videos, photos, or audio instances of animal cruelty. And they often expose not just egregious acts of violence, but inherently cruel practices that are systemic in the industry, things like castration of young piglets without anesthetics, or the keeping of mother pigs in gestation crates that are too small for them to turn around. In essence, an investigation exposes the problematic conditions of the facility in question. And these investigations are not looking for a needle in a haystack. Every one of the over 100 undercover investigations conducted throughout the US in the last 20 years has uncovered violence against animals, and often more issues such as worker safety or consumer health. Of the numerous investigations that have occurred in the past 20 years, many have uncovered horrific abuse and gained national attention. I won't go through each of these in detail, but there are more than a few notable results from undercover investigations into animal agricultural facilities. Perhaps the most cited investigation is Hallmark. This undercover investigation was conducted by HSUS and released in January of 2008. It documented the torture of downed cows in an attempt to get them to stand up and be then used for food. For instance, the investigation showed cows being pushed with forklifts and sprayed with high-powered water hoses to simulate drowning so they could stand up and then be used for human consumption. In 2015, an ALDF investigation at a chicken slaughterhouse exposed factory-like settings, including fast slaughter line speeds that caused animals to suffer from suffocation and mutilation on conveyor belts, and hundreds of chickens died before slaughter from neglect. The investigation depicted inhumane conditions for the workers as well at this facility. And a more recent undercover investigation that made big headlines was conducted by PETA into Invigo, a company that supplies live animals for research institutions. The 2021 investigation found 5,000 beagle dogs and puppies who were intensively confined to small, barren cages 24/7 at a massive breeding facility in Cumberland, Virginia. And that investigation predated the DOJ's initiation of civil proceedings against the facility for violations of the Animal Welfare Act that then led to those beagles' transfer. If the investigations had not occurred, an average consumer likely would not know of the systemic and individual instances of animal cruelty that are perpetrated behind closed doors. The companies tout animal treatment on their public-facing statements, which is the primary source of information an individual would have to learn about the treatment of animals from the industries that exploit them. For instance, this slide shows a summary of how animals are portrayed as treated by the Catelli brothers, who sell meat products made from young cows and lambs. They reference things that, such as ensuring the animal's well-being and emphasize humane treatment. But people don't know that these terms are actually euphemisms for animal cruelty. For instance, an undercover investigation into one of their slaughterhouses in 2014 showed something very different. Under the Humane Methods of Slaughter Act, cows have to be rendered insensible to pain before being slaughtered. And this is usually done with a captive bolt gun. but calves in Kentucky were shot numerous times before being rendered unconscious. So there's real value in not just telling people what goes on at CAFOs and slaughterhouses, and getting people to think critically about and not be deceived by animal welfare claims by these companies. The outcomes of undercover investigations are even broader than public education. They've resulted in criminal prosecutions. For instance, in Idaho, an investigation into Dry Creek Dairy led to the criminal conviction for animal cruelty against 2 employees. They've led to civil lawsuits. The Hallmark investigation led to a False Claims Act lawsuit, which resulted in a judgment against the defendants of nearly $500 million. And there have been legislative and administrative reform. Investigations at gestation crate and battery cage facilities have spurred state legislation and ballot initiatives to ban those forms of intensive confinement, which is something you all might have heard at an earlier presentation. This spurs some of the country's first on-farm legislation. Some facilities closed after an investigation is released, and there have been meat recalls. So the investigation to Hallmark again led to one of the largest beef recalls in U.S. history, 143 million pounds, much of which wound up in the National School Lunch Program. Another impact from investigations is seen in meat consumption. As the emphasized excerpt shows, media attention to animal welfare has negative effects on the demand for meat. So increasing media attention to animal welfare issues triggers consumers to actually purchase less meat rather than reallocate expenditures to competing products. Given these outcomes, it's not surprising that the industry wants to put a stop to the publicity surrounding investigations. But instead of eliminating the cruelty and suffering depicted, the industry's response is to kill the messenger by enacting Ag-Gag statutes that criminalize undercover investigations. So generally speaking, an Ag-Gag law is one that criminalizes or penalizes undercover investigations. They make it unlawful to engage in specific conduct, which is First Amendment protected speech, that is necessary to successfully carry out an investigation. And they can take different forms, but depending on the facility, they generally involve trained investigators who are hired or working on behalf of animal protection organizations. Those investigators need consistent and constant access to the facility. So they need to document conditions over a length of time to show the extent of harm and length of neglect, so that it isn't just employees who are implicated in some of the actions that are shown. It's also management that can be shown as complicit in the actions. The access is usually through employment, and to gain employment, investigators can lie on their applications. And these lies involve understating their qualifications, stating different reasons for needing employment, or not disclosing an affiliation with an animal protection organization, or things like liking the interviewer's tie. And once employed, the investigators perform all the duties required of them with the purpose of documenting practices and conditions at the facility. Specifically, they do this by obtaining audio or video footage or photography of the things they see. And Ag-Gag laws target some or all of those things. 10 states have passed Ag-Gag laws as we define it. Litigation has struck them down fully or in some portions in Utah, Idaho, Iowa, and Kansas. Current challenges remain pending in North Carolina, Arkansas, and Iowa again. And Ag-Gag laws remain on the books without challenge in North Dakota, Montana, Alabama, and Missouri. So you can see a legislative timeline of what Ag-Gag laws were first passed, beginning in 1990 with Kansas. You may also note that the passage of subsequent Ag-Gag laws really takes off in 2011. And this is as camera technology develops and investigations rise. The passage or the introduction of Ag-Gag laws peaks in 2012 to 2013, with 10 and 11 states introducing them respectively. And some of the laws have closely followed the results of an investigation's release, such as the Idaho Ag-Gag statute, which was passed after a 2010 investigation into Dry Creek Dairy in Idaho, which showed instances of cruel confinement and animal cruelty. The passage continues to this day, with states like Iowa playing a game of whack-a-mole by passing new Ag-Gag laws once a prior one is struck down. The claimed reason for the passage of these laws is usually along the lines of protection of privacy, private property, business interests, and food safety. But at a glance at the legislative history accompanying these bills, it often just shows animus. State legislatures arguing in support of laws call private investigators or investigators who go into these facilities on behalf of animal protection organizations terrorists or jackwagons. In Utah, legislators said that the recordings taken by investigators should be criminalized because they, quote, are used for the advancement of animal rights nationally, which in our industry we find egregious. And in Iowa, after a 2011 investigation at a pork plant generated media coverage of pigs and piglets being abused, a senator arguing for passage of the state's first Ag-Gag law said, quote, what we're aiming at is stopping these groups that go out and gin up campaigns that they use to raise money by trying to give the agriculture industry a bad name. In sum, it's very clear what these laws are intended to do, and these state legislatures are not acting alone. They're often influenced by ALEC and industry lobbyists, such as the Idaho Dairymen's Association and the Iowa Pork Producers Association. Of the many variations of Ag-Gag laws out there, they can roughly be broken into three types. The first are statutes that make it a crime to gain employment through a false statement or a misrepresentation. For example, investigations are employment-based and investigators hide their affiliation with an animal rights group or use a pseudonym for their name. And this can be seen in a state like Iowa. Then there are statutes that make it a crime to gain access to a facility by false pretenses, such as false speech. And lastly, there are statutes that require anyone who witnessed animal cruelty to turn over evidence of that cruelty within a specified amount of time. Investigations take weeks and even months to unfold, so all of the investigations mentioned at the beginning of the slideshow take much longer than 24 hours. If you want to show that pattern of abuse and show complicity of management, you need to run a longer investigation. And so laws that require you to turn over evidence of cruelty within 24 hours undermine those long-term investigations. And that type of law can be found in a state like Missouri. Then there are Ag-Gag statutes that combine some or all of those restrictions, such as Utah and Idaho. These are all criminal statutes that we're discussing, but there are also civil statutes that grant a private right of action to a facility being investigated itself. And those can be found in states like North Carolina and Arkansas. Because these laws target speech, often speech it engages in, ALDF and its coalition partners have been active in litigation challenging their constitutionality. The start of this litigation began in March of 2013, when an individual named Amy Meyer was traveling on a public right-of-way and took a video with her cell phone of a downer cow being moved with a front loader. Meyer was charged under Utah's law for agricultural operation interference. Those charges were later dismissed without prejudice after she demonstrated to the prosecutors that she was in fact not trespassing. But obviously the threat of erroneous prosecution has an enormous chilling effect on speech. In July 2013, ALDF filed the country's first challenge regarding an Ag-Gag law, Utah's, joined by PETA, Amy Meyer, and journalists. ALDF ultimately won the suit, and in this and subsequent litigation have challenged these laws under several legal theories. First, ALDF and its partners have brought several First Amendment challenges, including overbreadth, vagueness, and content and viewpoint-based discrimination. The latter, which has been the focus of the decisions, argues these statutes criminalize pure speech, specifically speech that is the act of making a misrepresentation on an employment application or to gain access to a property, or the act of taking photos or videos. And we argue Ag-Gag law's restrictions on that speech are content and viewpoint-based, since you must examine the substance of the investigator's speech itself to determine if the law was violated. Content and viewpoint-based claims must survive strict scrutiny. They must show a compelling state interest that was narrowly tailored to achieve that interest, which we argue the states cannot show. We also have included other claims to challenge Ag-Gag laws, such as preemption, namely that federal laws, such as those that protect whistleblowers, preempt state Ag-Gag laws. And we also sometimes include 14th Amendment claims, indicating that the laws are indicative of a legislative animus to target animal activists who are singled out for its application. And there are a bunch of Ag-Gag laws that have been passed and a lot of developments on their passage and litigation in the courts. One of the really interesting ones is Kansas, which I think Tom is the expert on. So I was going to turn it over to you.
Thank you, Caitlin. My name is Thomas Bondy. I'm an attorney at the law firm of Orrick, Harrington, and Sutcliffe. That is a global law firm with offices all over the United States and in Europe and Asia. We have an appellate and U.S. Supreme Court litigation practice, and that's the group that I'm a member of. I'm going to talk mostly about one case that we became involved in here with ALDF as the principal client. ALDF is a long time and highly valued pro bono client of our firm. I wanted to say at the outset that in doing what we did here, we worked very closely with one ALDF lawyer in particular, Christina Stella, and also with Professor Alan Chen at the University of Denver Law School and his team there. So just wanted to mention that. So what I'm talking about here today is Ag-Gag laws and the possibility, potential prospects for U.S. Supreme Court review, which might be a good thing or a bad thing, depending on the case and where you're coming from. But I'll be discussing this in the context of a specific case that all unfolded very recently. So let me see if I can get this thing working there. Yeah, there we go. So just as general background, and Caitlin alluded to some of this, there are Ag-Gag laws in a variety of different states. This is a nationwide phenomenon in the United States. It's not local, it's not limited. And most of these laws in the different states, there are about a dozen of them, have certain similarities. They all come from the same place and have a similar impetus, which is to prevent undercover investigations, or whatever you call them, incognito investigations, from going into animal facilities or crop facilities, agricultural facilities, seeing what's happening there and just telling the truth about it to the media or to the world, possibly via videotapes taken on the inside. And these laws are all aimed at trying to stop that kind of activity by regulating it and by criminalizing it, by making that activity a crime. So the laws are all similar in that respect. But it's important also to note that although the laws are similar and come from a similar place, they also have significant differences, and that matters in terms of a legal analysis. Some of the laws are focused on the sound or image recording inside. So what they focus on is once you get in the facility, you're taking a video, and that's the subject of the criminal sanctions. Others are just being there, just kind of in quotes, sneaking in by lying, by using false pretenses, by misrepresentation. Some turn on the intent of the person. So what is in your mind? What is in your intention when you undertake this investigative activity, as opposed to just the objective description of the conduct you undertake, like entering the facility by means of deception. So some have an intent requirement, some do not. Others, as Caitlin also alluded to, are criminal. Some are just civil, and the criminal ones vary. Some of them, a lot of them are just misdemeanors. Some of them actually impose felonies if you commit property damage and if the amount of the damage measured in a dollar figure is above a certain threshold. So that's kind of the background. So in 2021, the state of Kansas sought Supreme Court review in an Ag-Gag case. They filed a petition for a writ of certiorari in the U.S. Supreme Court, seeking review of a U.S. Court of Appeals for the 10th Circuit decision that held the Kansas Ag-Gag law unconstitutional under the First Amendment. You'll recall on that list of state laws a couple of slides ago, Kansas was one of them. Well, the 10th Circuit, in a lawsuit brought by ALDF and others, held the law unconstitutional under the First Amendment. So what did the Kansas state law say? Well, here is a little edited version. There's a lot of words. These are the key words. So a couple of important things about the Kansas statute. So no person shall, without the effective consent of the owner. What does that mean? The statute specified that you don't have effective consent if you enter the facility by deception. And other statutes use similar wording like misrepresentation, false pretenses. And my italicized language that will be important: intent to damage the enterprise conducted at the animal facility. I'll get back to that in a second. And then the two provisions are, and Caitlin alluded to this, a trespass type provision and an employment. This one doesn't have an employment provision. This is a entry provision, right? Just to enter a facility not open to the public. And then one that focuses on photographs or videoing. And if you do any of those things under Kansas law, you committed a crime. So why did the 10th Circuit hold that was unconstitutional? And of course, in doing so, they followed the arguments made by ALDF and the other plaintiffs. The 10th Circuit rested on the idea that this statute has a viewpoint discriminatory focus, and that it's not just based on what you did, it's based on why you did it and what your intention is. And in particular, it's targeted at people who go in and want to, for example, make a film, but do it with an anti-agriculture industry bias, if you will, which is reflected in the italicized language there, the intent provision with the intent to damage. And crucially, what the 10th Circuit said is that language, what that means is, or at least it includes, an intent to subject a facility to adverse publicity and, for example, an injury to its reputation. You go into the facility, you see bad stuff, you tell the world about it, maybe in a video, and that will hurt the facility by harming its reputation and by imposing adverse publicity. And the point of the 10th Circuit's decision is you could go in and do exactly the same thing, but with a different intent and not be subject to the law. For example, you could sneak into the facility, say you're a professor, you're an academic, and you just want to see what's going on at all these facilities. So you go in and you film it. You have no intention to help anyone, hurt anyone. You just want to know what's going on. So that's kind of a neutral intent. Or you could have a positive intent for whatever reason. You could go in and see what's happening and make films, all with the idea of showing that it's all great. There is no problem at all. What's going in there is wonderful. And all these three people are doing exactly the same thing, but with different intent. And the law only captures one of the three people, the person with ostensibly an anti-industry viewpoint. So the 10th Circuit said, whatever else might or might not be permissible, the First Amendment does not allow a state to discriminate among viewpoints that way. So that was the crucial aspect of the 10th Circuit's decision. There was a strident dissent that said all of that was wrong. So it's a 2-1 decision. So the 10th Circuit's, that's what the 10th Circuit decided. So what did the state of Kansas cert petition argue? They argued that the 10th Circuit was in conflict with an 8th Circuit decision in ALDF versus Reynolds that addressed one of the Iowa Ag-Gag laws. And I think, as some of you or most of you probably know, the main ingredient in getting U.S. Supreme Court review in any case is showing there is a so-called circuit split, a conflict among the U.S. courts of appeals, where one U.S. Court of Appeals, say centered in San Francisco, addressed a legal issue and came to an opposite, different conclusion than, say, another U.S. Court of Appeals, say, centered in Boston, First and Ninth Circuits. So here the suggestion in the cert petition, the 10th Circuit conflicted with the 8th Circuit decision addressing an Iowa provision. The Iowa provision there had an access provision and an employment provision, which are set out there in A and B. And this was a split decision. The 8th Circuit upheld the access provision, saying, yes, states can ban what is essentially trespass, even trespass by misrepresentation, but struck down the employment provision because they found that that provision lacked any materiality element. So you can lie or shade all kinds of things in an employment application context. You know, the interviewer is wearing a Green Bay Packers tie, so you throw in, hey, I love football, right? And this law covered all kinds of stuff like that without any suggestion that that lie or shading of the truth would be material to the employment decision. So the law was struck down on that ground. Cert petition also argued that the 10th Circuit was in conflict with a 9th Circuit decision in Wasden addressing an Idaho statute that also had an access provision and an employment provision. And the 9th Circuit there, at least superficially, did the flip of what the 8th Circuit did. The 9th Circuit struck down the access provision and upheld the employment provision. The employment provision didn't have the materiality problem that the 8th Circuit decision addressed in the context of the Iowa law, and the access provision in the Idaho context was struck down because of its enormous breadth. The Idaho statute could cover facilities that were open to the public and could even cover things like restaurants and grocery stores, depending on how they were set up. For example, if they grew some of their own vegetables, things like that. So the Ninth Circuit struck down the access provision there on the ground that it was just tremendously broad and too dangerous to speech activities. So what did we do? We filed a brief in opposition, successfully urging the Supreme Court to deny cert. So the Supreme Court denied the cert petition, and we worked with ALDF and with folks at the University of Denver to argue the court should deny cert. And very briefly, we said four things. We said, although it might seem that there was a circuit conflict and that these superficially, these courts were at odds with each other, including the fact that on each of these three panels, there was a dissent. Each of these three U.S. Court of Appeals decision was 2-1. But in fact, on closer inspection, there was no split. All these decisions turned on the distinctive elements of each particular state law. The state laws were different from each other in important ways, and the decisions differed from each other in terms of their legal reasoning. And the 10th Circuit decision in particular turned on the Kansas law's distinctive viewpoint discrimination. And neither of the other statutes had that element, and neither of the other Court of Appeals decisions turned on viewpoint discrimination. So we said, you know, when the smoke clears, there is no conflict. We also said, as Caitlin suggested, there's all kinds of other laws still being enacted in some states and being litigated. There's litigation ongoing in this space all over the country. So we said to the Supreme Court, you should wait and let things, as we say in Supreme Court parlance, percolate in the lower courts. That's the term that is used. Just let there be more litigation. And if and when there are more cases, and if and when there's an actual real conflict between the two circuits, then you, the Supreme Court, can jump in. The merits, we said the 10th Circuit was correct. Very briefly, our view was there might be all kinds of interesting legal questions about the extent to which a state can try to ban this kind of undercover investigative activity, which involves entering a facility under false pretenses. But what we said is the bottom line is it is clear that no state can do that using a viewpoint discriminatory statute. For example, you couldn't say these kinds of entries are illegal if you're a Democrat, but not if you're a Republican, just to give an obvious example. And we said the Kansas thing, it was viewpoint discriminatory, so it's just out. And we also, I want to mention the Supreme Court's Alvarez decision very briefly. The petitioners, the cert petition, supported, by the way, by an amicus brief from 11 or 12 other states, said the court should grant cert to revisit Alvarez. And you could talk for half an hour about Alvarez, but the Supreme Court in Alvarez struck down on First Amendment grounds a federal statute, an act of Congress that made it a crime to lie by claiming falsely that you had received a military honor. So I got the Bronze Star. I'm super brave. I got the Silver Star. In that case, I got the Congressional Medal of Honor. Aren't I great? And there's a federal statute, believe it or not, that said if you say that and it's false, that's a crime. You can go to jail. And the Supreme Court said, no, you can't do that. That's unconstitutional. In our system, you can't criminalize statements just because they are false. And I could talk about that much more, but there are a lot of underlying reasons for that, including that we all lie all the time. Lies, shading the truth, exaggerations, puffing yourself up, or lies to protect people, to protect your children, to protect the people you really care about. That's part of human discourse. And if all of that becomes illegal, like that totally changes the landscape of how governments can regulate speech. There was a 4-justice plurality in that case and a 2-justice concurrence. So it's kind of ambiguous technically what the exact holding is, although the holding is certainly that the law was unconstitutional. So the cert petition tried to sort of leverage that and say, oh, here's a chance to revisit Alvarez. That's why you should grant cert. But again, we opposed that and explained that the viewpoint discriminatory nature of the Kansas law made that sort of an open and shut case, and there was no reason for the Supreme Court to intervene. So just one more thing, looking ahead, where do we stand? So we fended off the Kansas cert petition. We thought that was a good thing to do with a good result. But just wanted to make clear there could be another cert petition in the future in an Ag-Gag setting, and it could be brought either by a state like Kansas, if one of its laws is held unconstitutional by a court of appeals, or by our side, by the animal protection side, from an adverse decision to us. And of course, the basic ingredient there would be there'd have to be a circuit split. There'd have to be a conflict between two U.S. courts of appeals, and who knows, that might happen. And we said here that hasn't happened yet. And might the Supreme Court take such a case? I think, yeah, for one thing, I think the issue is really important and it's super interesting. And the reason it's interesting, I think, is that you have a clash between just really important values here, the claimed privacy and private property right values. Those are the rights that are claimed by the agricultural industry. And of course, on the other side, just incredibly important free speech issues and journalism issues. Undercover investigations are super important. They have a long and kind of treasured history in the United States of uncovering really important truths and bringing those truths to light. And that's really what's at issue here. And particular justice, depending on how he or she feels about the relative importance of those values, you know, that could have a big effect on the outcome of the case if it were to go to the Supreme Court. But so far, one attempt to get there, we were on the opposition side and our opposition was successful. So that's where things stand for now. All right, that's it. I'm going to introduce our next speaker, Camille Labchuk. Like me, Camille is Canadian. And before I got involved in this case, I never heard of Ag-Gag laws. Before I got involved in this panel, I had no idea that Ag-Gag laws had spread to Canada. But for we Canadians, this is just proof of a well-known adage. If the United States comes up with a bad idea, it will eventually spread to Canada.
Okay, well, I'm Camille Labchuk. I'm a lawyer and the executive director of Animal Justice, which is a bit like the Animal Legal Defense Fund in Canada, an animal law advocacy organization. And as was just pointed out, we benefit from a lot of American imports into Canada. Yoko's cheese is great, Beyond Meat, Impossible Burger, but Ag-Gag laws are my least favorite one. So the history of Ag-Gag laws in Canada is actually quite different from that of America. We don't have a long history of undercover exposés in Canada. They did not really start coming out in any serious way until 2012 when Mercy for Animals came to Canada. I was part of that initiative in the early days. And, you know, there were investigations coming out repeatedly and frequently for a number of years. But, you know, in the early days before that, the farm industry claimed that it didn't want Ag-Gag laws in Canada because I think there was so much bad press about them in the United States, thanks to many of your efforts. So for a long time, we didn't really fear that Ag-Gag laws were coming because the industry itself said that they weren't. What started to change is these exposés really started exposing conditions on Canadian farms in a way that people couldn't ignore, and in a way that made the industry, of course, fear for its reputation. So CTV's W5 is one of the premier investigative programs in Canada. It airs once a week. It's half-an-hour segments. And MFA was successful, and other organizations as well, like Last Chance for Animals, in getting farm exposés covering virtually every industry of farming in Canada on W5. And these exposés resulted in a number of other outcomes for animals, not just publicity, but charges, particularly. There were dozens of charges laid in a variety of these cases. And in one case in particular in British Columbia, some of the highest fines for animal cruelty in Canadian history were levied against, unfortunately, workers, but fortunately management at a dairy farm. So the investigations and exposés started having a real legal impact as well that the farm industry did not like. But the impetus for Ag-Gag laws, I don't think in Canada was undercover exposés. It had more to do with some other types of activism on the ground. This is an image of a woman named Anita Crines, who many of you may have heard of. She founded Toronto Pig Save, which later morphed into the global Animal Save movement. And part of their ethos is bearing witness to animals who are on their way to slaughter inside slaughter trucks. So Anita stands outside, and her colleagues stand outside slaughterhouses in Canada initially, but now around the world. And they look inside trucks, they film conditions that they see. Sometimes we use those images to file complaints with authorities. And they also give water to pigs who are thirsty. And Anita was prosecuted for the criminal offense of mischief a number of years ago, about 2015, they started that case. For giving water to pigs, which became a global phenomenon and I think really drew a lot of unwanted attention to the industry. I think they really shot themselves in the foot by pushing for those charges against her. At the same time, we started seeing more on-the-ground activists entering without permission into farms and exposing conditions simply by releasing the photos and images on the internet. And funny enough, for a long time, they escaped any criminal or penal sanction. So this is a woman named Jenny McQueen, who's notorious in Canada for doing this type of work. And she faced a high profile, charge, and that was eventually dropped. A man who went on to a number of mink farms and exposed conditions there. His name is Malcolm Klimovich. You can see him in that image. Same deal. He ended up, pleading guilty to trespass, which is basically a, traffic ticket equivalent, and was never convicted criminally. There was even a criminal trial of which he was acquitted. So the industry was getting increasingly upset about the lack of criminal sanctions against advocates who went onto farms. Then we started seeing lockdown style events. So this is an event called Meet the Victims in British Columbia, where a number of individuals went to a pig farm that had previously been investigated and had some very troubling images coming out of the pigs. And they essentially locked down the farm, they live streamed to the internet and show people what's going on. The kind of the last hurrah before Ag-Gag laws arrived was this liberation lockdown in Alberta, which involved a free-range turkey farm. And, the reason that advocates in Canada felt compelled to do this work is that Canada, actually, our national pastime is feeling superior to Americans. But when it comes to farm animal laws, people are often shocked to learn that we're far worse. We don't have ballot initiatives. We can't get state or provincial level confinement bans. There's not really a single law regulating the use of animals on farms in terms of their welfare in Canada. So this is born out of real frustration at the system. So this is Jason Kenney, former premier of Alberta. He introduced the first Ag-Gag law in that province. Alberta is kind of like Texas North, fairly right-wing conservative. And the bill was introduced and passed in only 10 days. It passed without almost any debate. So this bill is this trespass statute. It amended the trespass statute to prohibit the entry without permission, including by false pretenses, onto any private property. This is not just farms. This is not slaughterhouses. This includes hospitals. This includes daycares. This includes nursing homes, centers where, in addition to farms, there's real concerns about the vulnerability of individuals warehoused within them. The fines are also significant, up to $25,000 for an individual and significantly up to $200,000 for a corporation. And that was obviously designed to target groups that might support these individual actions like Direct Action Everywhere or potentially Animal Justice if we were to do an investigation. But this bill passed very quickly without any public debate, without even media or journalists learning that it would affect their activities, which it would do so in a very, very obvious way. We started to learn more about the meat industry's work behind the scenes to lobby for these laws until the Alberta law was introduced. There was no inkling by any of us that this was in the works. But some of the largest meat companies in Canada were in fact lobbying behind the scenes for these anti-whistleblower laws. Ontario was next. The province introduced a Security from Trespass and Protecting Food Safety Act, and it passed in only about 6 months as well. The rationale for this bill, and I'll get to the text of it in a moment, but it's quite similar to Alberta, was billed as accomplishing two things. The first one is protecting animals from disease and stress. So really focusing on, the well-being of animals, ironically, and introducing contaminants into the food supply. So biosecurity and food safety. That's what you hear over and over again from government as the rationale for passing Ag-Gag laws. What Ontario did was prohibit entry into so-called animal protection zones, the mendaciously named term that they're giving to farms, slaughterhouses, and other places like rodeos and petting zoos and agricultural fairs where farmed animals may be kept. The bill made it an offense to interact with animals in those zones. So if I was standing on one side of a fence and a horse was standing on the other side and the horse came up to me and I petted the horse or a cow or a pig on the nose, that would likely be an offense. Also, to target folks like the Animal Save movement, they included provisions aimed at stopping people from interacting with animals on those slaughter trucks. So it's now an offense to interact with those animals, also an offense to stop a slaughter truck. So Save movement would often, stand up with their fingers 2 minutes in front of the drivers, and truck drivers in many situations had good relationships with the activists and would stop the trucks for a moment so they could do their bearing witness activities. But no more. And of course, no entry into any of these zones or stopping trucks or interacting with animals. Any consent provided to those activities is negated if given under false pretenses. It also provided pretty sweeping penal provisions, so arrest and private prosecution authority given to farmers, which was quite shocking, and as truckers as well, and high penalties, restitution, and cost recovery for private prosecution, which we're not aware of that existing in any other statute, really. 2 days after the bill finally passed, this woman named Regan Russell, that many of you may have heard of, was tragically run over by a truck at a slaughterhouse just outside Toronto and killed. She was there protesting the law, and the demonstration that day was specifically designed to draw attention to this bill. And the truck dragged her for many feet before she was finally killed. And it was extremely tragic. And we'll come back to Regan shortly. So during the process of passing this law, this actually did get quite a lot of attention, unlike Ontario, where there was not much public discussion. Sorry, Alberta, where there was no public discussion. Ontario did get quite a lot of press. I actually think that we probably did too good a job of drawing attention to it in retrospect, because the government ended up amending it and introducing some regulations to try to blunt the impact of the ban on undercover exposés to some extent. So during the legislative process and after the bill was passed, but before it came into force, they introduced some exemptions to the false pretenses provision. So there is a journalistic exception now, which we don't consider to be adequate to protect journalism, and certainly not undercover exposés by animal advocates. But the journalistic exception applies only if the journalist finishes their task and is never detected or asked to leave before they gather the information they're seeking. They have to comply with all biosecurity measures on the farm. Importantly, they cannot cause harm to a farmed animal, food safety, or an individual. What does harm mean, you ask? It includes things like causing stress or psychological injury to a farmer. So it's difficult to see how one could conduct an expose without a farmer getting hurt feelings over it. There's also a whistleblower exception, but this is only for employees who sort of already have a job on the farm and get evidence of illegal activity. And as we've heard, there's a quick report mechanism. So you have to report that immediately, which would blow the cover and the expose. Manitoba came next. The province passed some amendments to animal disease legislation. So this is really more squarely focused on biosecurity zones, but it does include some similar interference provisions. The worst that we identify is the interference with animals and transport trucks, which would likely result in animal safe movement activists being unable to do their work. This is an example of the type of work that they might do, which is standing in front of a truck on occasion for protest or just for a moment to be with the animals. Quebec has considered, this is in French, and I won't try to read it because I don't think we have a lot of French speakers in here other than me and Thomas, but Quebec has considered looking at Ag-Gag laws as well. They at one point struck a working group to do so. We haven't heard anything about this in a number of years, so everyone is hoping that it's no longer a factor. I will mention just quickly, I don't have a slide about this, but Prince Edward Island, tiny place, my home province, passed something that enhances biosecurity laws and makes it an extra offense to trespass onto a farm, punishable with a fine. Something very similar was actually proposed at the federal level in Canada. A conservative, roughly your Republican Party, they're in opposition right now, and their agriculture critic introduced a bill in February 2020 that would essentially make it an extra offense to trespass on the farm if doing so could expose animals to a biosecurity threat. So again, couched in this biosecurity language. The industry up here and politicians learned from the American experience, where we saw outrageous quotes from politicians stating, we've got to get these vegetarian activists. And they've been very careful not to bill it as an anti-activist measure. But there's a kind of a success story with the federal Ag-Gag bill, because we were able to defeat the first one. Through a lot of advocacy and support from our members, the bill went to a committee stage and was amended by a friendly MP such that anyone who exposed an animal to a biosecurity threat on the farm, not just a trespasser, could be liable. And that was a poison pill for farmers, because we all know very well that biosecurity adherence on farms is extremely poor by farmers and workers, and that's the real threat. So this is, the map where of places where there currently are Ag-Gag laws in Canada. I'm hoping it doesn't expand. I will say that there have not been any further recent attempts. There still are comments sometimes in the media by industry about Ag-Gag laws and how they would like more of them, but no legislator has taken it up. And I think that's in large part because there's been quite a big pushback, including litigation. which I'll speak about briefly next. So animal justice plus a journalist named Jessica Scott Reed, who writes animal advocacy columns and opinion pieces, and also a member of the Animal Save movement named Louise Jorgensen. We are suing in Ontario to challenge the Ag-Gag law. It has essentially a few prongs. So the fundamental basis of it is our Section 2B of the Charter of Rights, which is a constitutional document. 2B is roughly equivalent to your free speech protections in America, and it includes the freedom of expression. So that's the basis of our claim. But we're essentially claiming that restricting expressive activities and restricting people from using false pretense to gain access to a facility breaches the charter. In Canada, we have a balancing test that comes next if you find that there is a breach of that right, and the courts must consider whether the government can justify the breach as being proportionate to, the interests that they're trying to protect, rationally connected to an important policy goal, and minimally impairing. And we don't feel that they're going to be able to meet that burden. I don't think they've presented evidence yet to show that there's a concern that necessitates this law. Prong 2, we focused on activities of the Animal Save movement and the way they would be affected by this provision, specifically the act of interacting with animals on trucks and getting close with a camera to film and photograph those animals inside trucks, which has yielded evidence of animal cruelty. And the claim there is that this interact provision puts them at risk in their activities of being prosecuted. And finally, an extra claim is that the bill is excessive and punitive, and so violates these additional sort of Section 7 liberty and rights to security of the person rights, and the right against arbitrary detainment due to warrantless arrest provisions that farmers can exercise themselves, the ability of farmers to actually use force against people that they are arresting and be exempt from certain liability, which is obviously quite troubling. So I will wrap it up there. And just to say, as disappointed as we were in the sense that Ag-Gag laws came to Canada, it's also been a tremendous opportunity. Half of my theory of animal law is the Barbara Streisand effect, which if you don't know that effect, Barbara Streisand has a house in Hawaii. Someone put a picture of it on the internet. She got really mad, started suing all these people, and it became a news story. So she doesn't want attention paid to her house in Hawaii, but paradoxically, everyone's talking about her house in Hawaii. And I think that's what they've done with Ag-Gag laws. So I think our job as animal lawyers and advocates is to use the industry's own misdeeds as an opportunity to talk about what they're doing and sensitize the public to what this industry really is all about. Thank you.
Thank you all so much to our presenters. That was incredibly informative, and we are going to now open it up for questions and answers if anybody wants to come up to the mic. We may have some online questions.
Here's a virtual question. Are there other industries that use similar types of Ag-Gag laws?
Would anyone like to take that?
No, not that I'm aware of. The Alberta law that I mentioned in Canada would apply to other industries, but it wasn't motivated by them. Nobody outside of farmers was lobbying for that law. And I actually think that, almost no one in the public realizes that law exists. It really does, at least in Canada, appear to be very unique to the farming industry and their interest in protecting their profits.
I mean, I guess one analogy that comes to mind where the politics would be totally flipped are the laws in this country and sometimes the court injunctions intended to ban right to life people from doing whatever they want to do outside abortion clinics and reproductive health care providers, right? And they're also First Amendment issues. Never occurred to me until I just heard the question, but of course they're probably be a flip of what side one is on, politically.
Thank you. I think we have another virtual question coming.
With respect to outcomes of investigations and lawsuits that result in criminal or civil culpability, what types of punishments are the businesses or individuals sentenced to? And does the panel deem such sanctions fair and just, or what would they propose as an alternative sanction to do justice for animals?
I mean, I can speak a little bit about some of the issues involved in undercover investigations and appropriate outcomes. I think there's an increasing amount of concern about the consequences of exposés on workers who are themselves exploited by the farming system. And of course, tend to be the folks who are captured committing individual acts on camera. For a long time, these workers were really the focus of a lot of advocacy campaigns in Canada, and I know in the United States as well. And I think the tide has really shifted towards seeking corporate accountability for the actions and appreciating that these workers are themselves vulnerable and exploited and in an unfortunate position. So, I actually look back on some investigations and I'm disappointed to see some of the outcomes on workers. The extent to which management is able to blame the actions that their corporation has let fester on a few bad apples. It's always a few bad apples and rogue employees, the two phrases that they throw around over and over again. So, I think one thing that folks in Canada are very interested in moving toward is really focusing on corporate outcomes and liability for management and those really directing the issues.
Yeah, I agree. In the US, I know of 2 investigations who have led to criminal charges against individual employees. I'm not sure of any that have resulted in complicity for the organization itself, which is something we're interested in pursuing since it seems like they're being scapegoated for what's a systemic problem that portrays cruelty to animals. But you also need prosecutors who are willing to take action in the criminal context. And I wouldn't say that's been readily available after investigations. The probable result, the likely result of investigation is just in the court of public opinion. And I think that focus is mainly on the organizations themselves, the facilities that are conducting the abuse and not the individual workers.
The other thing I'd add, alluding to what Camille said about the workers, obviously what we're talking about here is mostly animal protection, animal rights, animal welfare. But often these investigations, from what I can tell, it's really 3-pronged. It's how are the animals being treated? Are there food safety issues related to that? And also protection of the people who work inside, right? Often the human beings who work in there, there's real issues about the treatment of them. And that's often, I think, part of the investigation, even if for what we're talking about here, that may not be the highest priority because we're talking about animal welfare and animal protection.
And just to add 2 things to that, Alberta's Ag-Gag law, which covers, every industry and is incredibly restrictive, was passed months before the pandemic started. A couple of slaughterhouses in Alberta were known as having the highest COVID rates earlier on in the pandemic. And of course had, largely migrant workers and folks on temporary working visas for temporary foreign workers. We considered whether it would be possible to go into that slaughterhouse and see what was going on, realized pretty quickly that the Ag-Gag law would prevent us from doing that. But part of the reason was not just to, look at animal issues, but to look at workers' rights issues as well. And so I think allying with those groups is important. And one thing I'm really proud of in the Ontario case that we filed is we haven't gotten to the stage of, formally having interveners accepted in the case. And interveners in Canada is roughly equivalent to an amicus in the United States, but sometimes with slightly more rights of argument and to present more fulsome information. But one of the interveners is a group called Justice for Migrant Workers, and they are very obviously social justice oriented, including justice for animals, and think it's important to be there, not just for animals, but of course for the interest of their members who may wish to report something, but are in this especially vulnerable position of being migrant workers and without many rights, employment rights in Canada, and fear increasingly for their safety of being, able to make those reports without consequence.
Yeah, I think those are such excellent points. And just noting that it's systemic, all of these issues, and COVID has really uncovered so much for us as we view the lens of factory farm work and whether it is the workers, the animals, et cetera. And it's so unfortunate because the folks that are doing their job, it's condoned, it's sanctioned. This terrible mistreatment of the animals and the quota and the bottom line and all of that is at stake. So it really is, perhaps to your point, Camille, an opportunity for us all to explore a little more deeply the intricacies of the industry and educate the public. So to their detriment. So, yeah, I don't know if we have any other questions. I do have my own, if I may ask that. Caitlin, in your original slide, you had noted about 2012, 2014, there was an extraordinary amount of Ag-Gag bills that were introduced. And do you see that there's a drop off now? What would you attribute a drop off to now? And I'm hoping you're going to say some of our success.
It's a good question. I'm definitely going to say our success. We first filed a lawsuit in 2017. So just a couple of years after a lot of legislators tried to enact Ag-Gag bills in 2012 and 2013. A lot of those weren't actually successful to begin with, so they weren't passed. You saw the map of the Ag-Gag laws that are on the books. There's only about 10 of them. So I will say there is some resistance in the states themselves to pass Ag-Gag laws in certain states. Then I think our success has been pretty good. Ag-Gag laws have come out favorably for First Amendment rights. We have been waiting on motions for summary judgment and we're not proceeding to trial. So we're getting victories early. And on appeal, most of them have been held up. So I think that it's really a game of whack-a-mole, as I said earlier, where we're having success. Some states who have big industry influence are trying again, but they continue to have problems because really the root of these laws is they're trying to target animal activists, and those laws are inherently unconstitutional. So I think, the outlook is bright, and hopefully our work will continue to incentivize the passage of new laws in the future.
Wonderful. Camille, would you say the same for Canada?
I think so. Yeah, there was a moment where we were quite fearful. There was other provinces I didn't mention where folks were sort of musing about this, and it seemed like we were in for a wave circa 2011 in the United States. And I think it's thanks to the strong opposition mounted by the animal advocacy community that we were able to stall those additional bills for coming forward. I think for any province that would be considering it, they would look at the fact that there's pending litigation and be fearful of becoming embroiled in that themselves. We also did one last undercover expose that came out a week before the laws finally came into effect in Ontario. It was kind of like a last hurrah, which is on that program I mentioned, W5, just to remind folks that Canada or Ontario was looking at moving in this direction. And, I think that was successful as well. And, showing politicians that people are very upset about these issues. I've got to say, like the work that we've done in Canada and with animal justice, I don't think any other issue is connected with folks as strongly as Ag-Gag laws. Certainly inspires more emotions, more upset and more anger about the state of affairs, and not just from people who already consider themselves animal advocates. And I think if you're a politician, you don't want to ignore that because, if this picks up enough speed and takes on enough attention, it's something that could actually affect the way people vote.
Yeah. And Tom, I think to your original point earlier, this was not something that you were aware of prior than working on this case. What has your personal perspective been on this, and have you, along with your friends and family, has this conversation been had? Are you now a champion?
Yeah, I find these laws kind of outrageous. And the first thing I did when I got involved in this, because I knew nothing about it, is I read Upton Sinclair's book, The Jungle, which I would recommend to people. Probably everyone here knows about it and has read it. And the idea that the activity underlying the writing of a book like that could have been squelched and made subject to a crime is just obnoxious, totally obnoxious. That book, besides being, I think, a beautiful work of literature, revealed to the country truths that needed to be revealed, truths about treatment of animals, about the agriculture industry, about food safety. And that book, my understanding, has led to the first food safety statutes in the United States. And of course, to the horrific treatment, absolutely horrific treatment of the human beings who worked in those facilities. And I think most people, if they're exposed to this, would find the whole notion kind of outrageous. But does that mean all the lawsuits will win and would ultimately win if they go to the highest court? I'd say at that point, all bets are off.
Yeah.
That's kind of the paradox of the claims the government makes to justify passing Ag-Gag laws. Of course, in Ontario, it's really focused on food safety. And just to drill down into what they mean by that a little bit, it tends to be folks interacting with pigs inside a slaughter truck could introduce a disease or a contaminant. And, it's not like it's an illegitimate concern. There are diseases out there that could be transmitted to pigs. But when you think about it, these pigs are on their way into the slaughterhouse. They're going to be killed immediately. There's no time for a disease to develop. And when you really drill down into the details, it's not a legitimate food safety concern. But when you think about the history of Upton Sinclair and all the, gosh, I'm forgetting the name of the 2008 Hallmark case, that really, obviously had a huge impact on the nation in terms of food safety and what was revealed there. So really, these are tools to enhance food safety, not undermine it. And it's pretty mendacious for governments to pretend otherwise.
The other thing I'd add, you can say there are good things or bad things about our legal system in the United States, but generally it's really hard for governments to regulate speech. That is just really hard to do. And that's a good thing. And it's still really hard today. And, Kansas did what it did, and it crossed a line you can't cross. And especially regulating and criminalizing speech because of its content, that is a hard, almost impossible thing to do in the United States. I don't know if it's easier to do in Canada because Canada has a sort of balancing test that it applies to these things that are akin to our intermediate scrutiny as opposed to strict scrutiny. But I think that's something helpful to keep in mind, that if you're a politician and you want to restrict speech, which is what these things do, even if ostensibly you're doing it for what you think is a good reason, that's a hard thing to do. And it's a really hard thing to do if you do it carelessly, if you don't put a lot of thought into how you're going to do it.
Yeah, and to go off that point, there are already laws in the books that prohibit trespassing.
Right.
So these laws are just an added penalty to people that tend to disagree or have harmful speech that's truthful at the end of an investigation. It isn't the initial speech in the employment application or to gain access to a facility that these facilities are worried about.
Right. And of course, these aren't really trespass laws. The harm here to the industry isn't trespass. All these states, believe it or not, already have trespass laws on the books. The harm is the criticism that would come from divulging what is, after all, the truth. That's the harm that the industry is seeking to, forestall.
I'll just add a tidbit about the Ontario case that we've already filed, and goes to your point about trespassing. Obviously, there's a trespass statute already in Ontario, and it would be an offense to go into someone's property unlawfully. The government, I think, is having a challenging time defending the legislation because there is already a trespass provision. So when they say this is about biosecurity and protecting food safety, they have not been able to articulate the difference between an employee who's wearing a camera and their effect on biosecurity or food safety, and an employee who's not wearing a camera. So the evidence that they put forward in the case, and they put forward, I think, 19 affidavits, mostly from industry folks, mostly kind of copy and paste jobs. It was kind of shocking, really. But they're mostly farmers saying, oh, I'm so scared because activists might come onto my farm. There might be an occupation or a lockdown, and they could scare my children who live on the farm. And these are also our homes. So it's really focused on extraneous issues that don't go to the heart of the case at all. And so, I think that's a real challenge. They can communicate it about Ag-Gag in terms of trespass, but that's not what the legal issue actually is. And when you get before a judge, they can cut through that crap.
I don't want to leave it on that.
Yes. Another virtual question. With respect to the Kansas Ag-Gag statute, if there was no intent provision, would the 10th Circuit likely uphold the statute?
That's a great question. And I think the fair answer is we don't really know. The court focused like a laser beam on that aspect and said over and over again in its fairly lengthy opinion, that's all it was talking about. And it wasn't talking about anything else. And again, that goes back to the general sort of framing of the case under the U.S. Supreme Court's Alvarez decision, which addresses the broader issue. And it's a really interesting issue of the extent to which in the United States, governments can ban speech solely because it is false. If you say something that is false, is that a reason that the government can ban it? So no, honey, that dress does not make you look fat. Is that a crime? Or if I tell my kid, no, the man on the TV did not just say blah, 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 that would be really bad. He didn't say it, even though that's a lie. I'm trying to protect my kid from the harsh truths of the world. Where the line is, you can lie, you can prosecute people who lie to commit fraud, right? No doubt about that. You can prosecute people who lie to commit defamation, right? Who slander other people. You can lie to people. You can ban lies. One of the contexts in which the Supreme Court has suggested you can ban lies is in the employment context. But, you know, it has to be properly, narrowly tailored, where you lie to get a job. But where you just lie, as opposed to trying to lie to hurt someone in a specific way, or lie to get a gain for yourself, generally the government can't ban that. But where the lines are and what the legal test is was sort of left a bit hazy in Alvarez. And that to answer the question, the 10th Circuit would have to address those issues if it couldn't rely on the viewpoint discrimination point. And I don't think anyone knows how that would come out, but maybe others have a different view.
Yeah, and actually, just while we have a moment, I did want to give a shout out to the law firm of Foley and Mansfield for their help, their pro bono assistance on that Kansas Ag-Gag case. So thank you so much. Yay, right in the room here. Hello, thank you. And I know we have so many students that are in the room. I hope you don't mind a raise of hands, because Ag-Gag, I think, brought so many of us to the table into the movement. Are there a lot of folks here that this is their issue and this is what brought them into animal protection? Oh, well, you all are solving the problem for the next generation. That's wonderful. Any additional questions or virtual? Thank you.
So this one was for Tom. With Canada introducing federal Ag-Gag legislation, is there any chance that the U.S. could follow Canada by introducing any type of a federal Ag-Gag bill?
Yeah, I don't know, and others might know better than me. I am not aware of any federal legislative activity on this front. From what I know, it's just been state by state. But Caitlin, do you know
Yeah, I'm
more
not
than
aware of that or any inklings of that.
Yeah, and just to be clear, Canada follows the U.S. The U.S. doesn't follow Canada. That's not how it works.
And I can say, I mean, with the current administration, there's not much moving, and I don't believe that there's an appetite for this at the federal level. It would be hard fought and a very long battle, because we have so many friends on the Hill. So legislative wise, it's not a consideration at the moment. But of course, with every state legislature, with farm bills, I mean, we really have to be on top of our game and aware of the work and the language that's being introduced in each and every forum, because there could be something that is slipped in, and without having gatekeepers at the legislative level to fight that, to ensure that we strike some language. I mean, it's really important to work together, both legislatively and with litigation teams. So really appreciate that.
And also, I'm just dreaming here. This isn't going to happen, but it's actually more plausible to imagine in the right administration a federal law in this country that would ban Ag-Gag laws. That's almost more plausible, but that's not going to happen.
Equally as
you can imagine it happening.
Yes. Yes.
This one was for Camille. Are there any ways that farm workers in Canada can legitimately report animal cruelty or neglect to proper protection agencies and authorities?
Yeah, I mean, I think most provinces still don't have Ag-Gag laws. I think there's always a concern, in the Ag-Gag provinces about doing that. Ontario is a bit of a special case, and if anybody watching is, considering doing that, or has somebody that they're advising who's considering doing that, it would be important, I think, to get some solid legal advice on that, because it's quite complex at the moment. And somebody who doesn't report cruelty in Ontario, who's a farm worker in the proper way, I think could be liable for prosecution if they're not deemed to have reported it quickly enough. So, this is part of the point of these bills, is to deter people from getting involved in, considering animal cruelty in the farm in the first place, and certainly reporting it.
Yeah, at the beginning in the first talk, there was a list of all the different Ag-Gag laws and all the different criminal cases that had come about. And at the very end, there was the Envigo case with the beagles. And with the recent activities that have been going on, I think it might be a good timing to do some retrospective advocacy, because very often there's people that are interested in one issue or another. They may be interested in companion animals, where somebody else may be more focused on agricultural issues. And with the publicity going on right now, I think it would be good timing to just the people who pay attention to the beagles may not know anything about the Ag-Gag laws. So this would be a really great time to take advantage of just all the publicity. I mean, I live in Virginia, so this was my senators and my representatives that were very active in trying to get this case moving. So in addition to all the other NGOs that were involved.
It's wonderful work and much appreciated. And that connection is there, and agree that it does provide an opportunity to expand the conversation beyond just companion animals to those that most people either don't want to talk about the issue or recognize the issue of the plight of farmed animals. So great point. Great point. And I do believe we may be ready to wrap up. We're at the end of our session right now, and I would like to thank our incredible presenters for their expert insight on Ag-Gag laws, and for all of you for attending.